All right, well, it is 10 a.m., so we'll go ahead and get started. Thanks everyone for joining. This is Jeremy Rogers, the Director of Legal Affairs at Oregon Realtors, and today we're going to be learning about the Oregon Realtors Form 1.5 Vacant Land Purchase and Sale Agreement. There are just a few housekeeping items. The chat is open, but if you could use the Q&A function, if you have any questions, that would be our preference, because then we can more easily spot the questions over the comments and can click on those once we have answered that question. Please feel free to answer any or ask any questions that you have. We want to get through all of them. Can you please make the text larger? Okay. Not sure I can do that on this presentation right now, but this is just the opening screen, so I don't think it'll be a problem later on. So we will get going here, and yeah, please ask any questions that you have. We want to make sure we get all those answered. And I'm not certain that the prepared content here is going to take a whole hour. We want to make sure that we get through your 50 minutes for your CE credit. So hopefully there will be questions. And after I go through the presentation, if we still have any time, I'll just go ahead and pull up the document itself and walk through it in more detail. All right. Okay, so what we want to cover today, first, we're going to just give you a brief overview of some additional training materials that are available to you in addition to this course that you're taking today. We want to talk about the use case for the vacant land purchase and sale agreement, and especially the use case for a vacant land agreement as compared to the residential agreement or the agricultural agreement. We're going to talk about the differences between the vacant land agreement and the residential agreement. We're also going to talk about differences between the vacant land agreement and the agricultural sale agreement. We're going to talk about our Form 3.3 vacant land disclosure, and then we'll do Q&A. We are not going to just walk through the whole vacant land sale agreement, because I am presuming that most people who are taking this course have already been through a course where we walk through the basic structure and content of our residential sale agreement or some of our other sale agreements. And so I didn't want to repeat all of that for folks. So we're going to really highlight the differences here between the vacant land and the other documents. As I said, if we get through all the content, then I'll go ahead and pull up the document and just walk through it section by section. So I want to just give a brief overview of some of the training materials that are available to you. Hopefully you've made use of these. We have the website orforms.org. That is your hub for all things Oregon Realtors Forms. And on that website, there is a training section. Sorry, here am I trying to get my, there we go. If you click that training tab, that's going to take you to our training library page. On that training library page, you're going to see several options. I want to highlight this option here on the left, which is the self-paced training. So every time we do one of these live trainings, we record it and then we upload it into Online Ed and we make it available for CE credit. Sometimes there's a lag. So when you go into the self-paced training tab, you may not see everything that's going to be available. It may take a week or so to get it up there. But if you'd like to, if you've missed any of these live trainings and you'd like to take them for CE credit, you would use our self-paced training tab. Here's what that looks like here. There is typically a cost of $15 for the CE credit for those courses, although the Using Oregon Realtors Forms training, which is our baseline level training on the residential agreement, is a free course. We also have recorded tutorials. So if you know that we've done a presentation or a webinar, but you don't see it in the self-paced training for CE credit, it's likely that it will be in our recorded tutorials, which is our YouTube channel, essentially, but not available for CE credit. So if you're just trying to get to the content quickly after we've done a presentation, go to the recorded tutorials and you may find what you're looking for there. And in there, we do have recordings of previous presentations on the agricultural sale agreement, the commercial sale agreement, the residential sale agreement. And over time, those will be moved into the self-paced training for CE credit if they're not there already. We have our virtual open house that takes place at 11 o'clock on Fridays. So after today's session, you can hop on over there. Nicholas, our staff attorney, will be staffing that today. It's always available at 11. So if you have any questions you don't get answered today, any questions that you didn't get answered from previous trainings, or any questions generally, we're always there for you at 11 on Fridays, where you can ask questions of the attorneys who drafted the forms. We also, of course, will continue to do live trainings and webinars. I think we're running out of the ones that we have posted for upcoming live trainings and webinars, but we are, in fact, today meeting to talk about the next round of live trainings and webinars. So soon we will announce additional live trainings and webinars, and likely those will continue to occur Fridays at 10 a.m. Also wanted to point out to you that our guided forms library has recently been updated. So the guided forms library is an opportunity for you to open up one of our forms, and within that form, see a little video icon next to every provision in the form. And you can click that video icon and get an explanation of that section or provision of the form. Just yesterday, we added a whole bunch more guided forms, including the vacant land purchase and sale agreement, which we're talking about today. So after we go through today's presentation, if you'd like to kind of go back and remind yourself or learn more about a particular provision, open up that guided form, and there'll be a video there, usually 30 seconds or so on each section of the form. So there it is highlighted. So let's talk about the use case for the vacant land purchase and sale agreement. So we define the use case in the form itself. In Form 1.5, Section 1, we describe that, that this is to be used for a property with no dwelling structures and with no agricultural, commercial, or industrial uses. Now, I want to highlight the word uses because that is how we are distinguishing between which form you should be using. It's not based on zoning, it's based on use. So you could use the vacant land agreement for a residential, commercial, industrial, farm, forest, recreational zoned land. It's really about the use of the land that is going to dictate which form you use. So let's talk a little bit about use case in terms of the vacant land versus the residential purchase and sale agreement. So obviously, if your buyers are wanting to purchase a home to live in, they care about whether there's a dwelling structure on the house. But there's other reasons we care as well in terms of drafting these forms, because we want to make sure that the buyer and seller are complying with all laws that are related to the particular type of transaction that's taking place. So there are laws that are going to apply when there's a dwelling structure that will not apply when there is not a dwelling structure. And that's one of the reasons why we care as drafters of the forms, which form you're using. So one of those, of course, is the seller property disclosure statement law, which states that it applies to real property consisting of or improved by 1 to 4 dwelling units. Unfortunately, that statute does not further define what a dwelling unit is. And in fact, if you look throughout the Oregon revised statutes, there are multiple differing definitions of dwelling unit for all sorts of different purposes in the Oregon statute. So there isn't sort of one reliable definition of what a dwelling unit is in Oregon statute. Now, the federal laws, the lead paint laws, apply to housing constructed before 1978, okay, with a few exceptions. And they define that as target housing. Okay, but again, there is no excellent definition of what they mean by the word housing. Okay? And finally, there are just some choices that we made in developing these forms of not including certain items that are in the residential purchase and sale agreement, in the vacant land purchase and sale agreement, because we didn't believe those items would be relevant for vacant land. We're going to talk about those today, but there are several items that are just not in the vacant land agreement. The vacant land agreement is shorter than the residential sale agreement because it does not include those items. So as you're thinking about this and trying to understand what's a dwelling structure in terms of using the residential agreement as opposed to the vacant land agreement, I mentioned there's no single definition in Oregon law, but the Oregon Residential Specialty Code, of all the things I've seen, I think provides the most help in understanding what a dwelling unit is. And it defines a dwelling to be any building that contains one or more dwelling units used, intended, or designed to be built, used, rented, leased, let, or hired out to be occupied, or that are occupied for living purposes. It defines the dwelling unit as a unit providing complete independent living facilities, including permanent provisions for living, sleeping, eating, cooking, and sanitation. Okay. So again, there is, for the purpose of the contract, there is no perfect definition, but hopefully this is helpful. And I think the default rule for you is to say, if you are unsure, if there is any kind of a structure on the property, and you are unsure if that property is a dwelling, then use the residential purchase and sale agreement, because in terms of your risk management, there are items that you have to take care of and deal with in a contract if there's a dwelling unit that you don't if there is not. And so from a risk management perspective, you're better off using a residential sale agreement if there is any doubt. Okay. And the reason why we're talking about this is because we get questions all the time about, well, there's, you know, some abandoned structure on this lot, otherwise, you know, it's a vacant lot. There's just, you know, a rundown structure. It hasn't been used for living for quite some time. Those types of issues. I see some questions in the Q&A, so let me pull those up. What if there's a shop or a garage? Can we still use this form? Yeah, so if there was a shop or a garage and that shop or garage reasonably, okay, would be presumed to not have been built for or to not be used for residential purposes, then it's unlikely to be considered a dwelling unit. And then that's on the residential side, but then you're also going to want to say, is it being used for commercial purposes? Okay, I mean, is there any kind of commercial activity or business being run out of the shop or garage? If so, then the commercial agreement would be more appropriate. But if there is just a structure that's a shop or a garage that's not designed for or really capable of living in, and it's also not being used commercially, then you could use the vacant land agreement. Okay, what if the dwelling is an older manufactured home? Do we still use the seller property disclosure statement? Anytime the manufactured home is affixed to the real property underneath it and they're owned by the same person, you're going to use the seller property disclosure statement. Okay, so you would use that if you're doing a real property transaction with the manufactured home. If you're talking about a manufactured home in a park, then you don't need to use the seller property disclosure statement. Now, of course, we do also have the vacant land disclosure document. We're going to be talking about that today. That answers my question. Okay, great. What about an uninstalled trailer, RV style, not manufactured? Yeah, so if it's uninstalled and it's an RV, not a manufactured dwelling, then that RV is going to be personal property. The land would still be vacant land. Okay, and then you're going to presumably either that RV is going to be moved off the property, or if it was going with the property, you'd need to deal with that as a personal property transaction. But if it's an RV style vehicle that's just sitting on the property but is not installed on the property, then that would not be considered the dwelling unit for the purpose of a residential sale agreement. And you could use the vacant land and then separately deal with the personal property issue of the RV. All right. Great questions. I knew that this was going to be something people wanted to talk about. So as I mentioned, if you're unsure, use residential, because it's going to cover you for things to make sure that your clients are complying with state and federal laws. So next, let's talk about vacant land or agricultural PSA. So our agricultural sale agreement also defines the use case for the agricultural sale agreement. And we say the production, cultivation, growing, husbandry, harvesting, or processing of farm, forestry, marine, and game products. 2, solar or other natural resource extraction, or 3, animal or plant conservation programs. Now, obviously, there's a lot of words in there, and each one of those words we could spend hours trying to define. So I think one of the best ways to think about this is if you really have to think about it in terms of usage. Is it being used for those above purposes? The fact that there are trees on the land doesn't make it an agricultural land. Okay, it still could be vacant land, but it just has trees and vegetation on the land. Is it being used for the growing of those trees, or for the cultivation of those trees, or for the harvesting of those trees? Then that would make it agricultural land. Okay, so you really have to think about it in terms of the use, not just what's there. Okay, because a lot of vacant land is going to have, trees are a good example, but some of these items up here, but it's not being used for that. Okay, and then again, what I would say is if you're unsure, then you want to use the agricultural sale agreement. And the same would be true if it's commercial. If you're not sure, like if this would be considered a vacant property or a commercial property, use the commercial sale agreement, because you're going to be covering things that are going to be protective of the buyer and seller related to commercial, or you're going to be covering things that are protective of the buyer and seller related to agricultural that are not in vacant land. Vacant land is the most stripped down of our sale agreements. And so if you're ever on the edge of which one you should be using, use the one that contains more items and more protections for the buyer and seller, because at the end of the day, it's a good risk management practice, and it's more likely that you're going to be able to deal with any issues that come up. And if there are items in those sale agreements that aren't relevant, then no big deal. They're just not relevant. Okay, but it's better to have some items that aren't relevant than it is to not deal with issues that need to be dealt with. Let's see if there's any more questions here. Okay, no, all right. Just click off these questions really quickly. All right. So that is the use case on vacant land as compared to agricultural land. Now let's talk about some of the specific differences between the vacant land and the residential purchase and sale agreement. So the vacant land purchase and sale agreement contains no provisions related to lead paint or lead hazards. That is because the federal law for lead paint and lead hazards only applies if there is target housing on the property. Okay, and presumably in most cases there is going to be not even any structures on the property. Okay, so we're not going to be having to comply with our federal lead-based paint laws, and so those provisions are stripped out of the agreement, and the lead-based the lead hazard addendum would not be used. Now, there's no reason why a buyer can't ask for protections or opportunity to inspect if there was some abandoned structure and they wanted to know if there was lead there. Okay, it's just that the law is not going to apply, and that particular disclosure document required by the federal law is not going to be required. Vacant land purchase and sale agreement contains no provisions related to new construction. Okay. So those are included in the residential sale agreement. And of course, if you're taking our training, we have an addendum that would deal with new construction. That stuff's all stripped out of the vacant land purchase and sale agreement. There are no provisions related to tenants on the vacant land. I mean, a question came up earlier. Well, what if there was an RV on the land that wasn't installed? And presumably, there could be a tenant living in that RV. Okay, so it's not inconceivable that there's a situation where the underlying sale agreement is really more of a vacant land agreement, but there are tenants because they're in an RV, but our document doesn't contemplate that particular issue. We've stripped out the tenant related provisions in our vacant land sale agreement. There are no provisions related to home warranties in our vacant land sale agreement. Because there's no home that a warranty can be purchased for. There are, this is one that you should know, it's kind of down in the weeds, but our vacant land sale agreement does not contain a requirement that the seller agree in writing to invasive inspections. So our residential agreement states that the seller must agree in writing to invasive inspections, but it also defines a handful of inspections, including radon, sewer scope, pest and dry rot, locating an oil tank as non-invasive. Whereas the vacant land agreement just does not even include the requirement that the seller approve of invasive inspections. So with our vacant land agreement, things that would be considered invasive inspections would be already included in the right that the buyer has to inspect the property. Of course, The buyer can't do damage to the property. The buyer would still need to restore the property to its previous condition, but we did not include that specific written requirement for seller to approve. I'll get to that one in a second. Another one is that the vacant land purchase and sale agreement, we have created a separate disclosure document called Form 3.3 Seller's Vacant Land Disclosure. You do not use the Form 3.1 Seller Property Disclosure Statement, and Oregon law does not require that there be a specific disclosure statement, but we still created one for vacant land, and our contract does require that it be used. So even though Oregon statute doesn't say you have to use it, our contract creates the contractual obligation that you do have to use Form 3.3 vacant land disclosure. Now, even if we did not have a vacant land disclosure document, a seller of vacant land would still be obligated under common law and under the contract, because under the contract, they're saying that there are no material defects. They'd still be obligated to disclose any known material defects to a buyer, okay, regardless of whether we required the specific Form 3.3. But fortunately, we've created the Form 3.3 as a way of making those disclosures. And we did so in a way that's much more specific to vacant land issues. We'll go through that later today, but I think that you'll like that document as compared to the 3.1 seller property disclosure statement for all the particulars we put in there that are going to be more relevant in the vacant land context. Another change is that the vacant land PSA includes one of the seller representations. Okay, so all of our documents have a seller representation section. In the vacant land PSA, it's section 33. And one of those representations in the vacant land agreement that's not in the residential agreement is related to water rights. And it's this representation here that the seller represents that they have authority to transfer all water rights associated with the property, that they can verify seller's beneficial use of the water rights associated with the property within the past 5 years, and that they have no knowledge of any existing claim for causes of action that could terminate the water right. Okay, so figured dealing with vacant land, more likely that water rights issue is going to be involved. Wanted to include that here. That's also included in our agricultural sale agreement, seller disclosure section, or seller representation section. All right, we have some questions. Let's hit those. I have a vacant land listing that has a septic and electrical. It previously had a dwelling unit, but it hasn't been, but it's been 14 years. It also is F2, vacant land or residential. So if the fact that it has septic and that it has electrical running to the land, if the actual dwelling unit that was on it is destroyed and is no longer there, you would still use the vacant land sale agreement because there's no dwelling unit on. So just the fact that it's set up for a dwelling unit because of the septic and electrical does not make it have a dwelling unit, and therefore does not make it for the residential document. You'd still use the vacant land document. Okay, Patrick asked, wouldn't it be good to have invasive inspection language, example, perk test? Yeah, we'll take a look at that. I mean, I think the good news now is that the way we have it set up, the buyer is going to be able to do invasive inspections. I mean, our due diligence section encourages the buyer to test the property and the soil and other things that they believe that they need to do their due diligence. And so the buyer is going to be able to do those things. But if our members believe that there should be a written requirement, written approval for some invasive inspections from seller, we'd be open to making that change in the future. But currently, buyer would be able to do those, and we think that's important for buyer to do some of those. And of course, if there is septic or if there is a well, the buyer can also still use the septic and well addendum to do those inspections and have contingency around those inspections. All right, thanks for the questions. All right, so let's talk about some of the difference between the vacant land sale agreement and the agricultural sale agreement. Now, the agricultural sale agreement is much more extensive than the vacant land sale agreement. It covers many, many items that would be relevant if there was agricultural use of the property. And so again, if you're ever on the the line, you're not sure, is this property being used for agricultural uses or is it vacant land? Use the agricultural sale agreement because the parties are going to be more protected and be prompted to deal with more issues that could be relevant. But let's just talk about what some of those items are that you're going to find in the agricultural sale agreement that you will not find in the vacant land agreement. So as you all know, the way our agreements are set up is the specific terms are on the first page. There are a series of items of specific terms in the agricultural sale agreement that do not exist on the vacant land sale agreement, including the question on crops, whether the seller or leaseholder retains any ownership interest in any crops on the property after closing, the question related to timber, whether the seller or leaseholder retains any ownership of timber on the property after closing, grazing rights related issues, mineral rights related issues. Okay, and this is an important one to think about, right? Because you could have something that otherwise looks like vacant land, but there are mineral rights involved. If that were the case, use the agricultural sale agreement, okay? Because you want to deal with those issues in the sale agreement itself. Those are important issues to address with lots of legal rights that need to be dealt with in the language of the sale agreement. A lease, will the seller use the property for commercial agricultural resource extraction after closing? Okay, and then prompting folks to use our Form 7.4 agricultural tenancy addendum. That is not in the vacant land agreement. Okay, so those are a few items on the specific terms that you're not going to find in the vacant land. Now let's talk about the time period terms. So the next section of our document are the terms that have a time period associated with them. There are a whole series of those in the agricultural purchase and sale agreement that are not in the vacant land purchase and sale agreement. So there's a whole section on crop harvesting and a seller or leaseholder having a right to come back to cultivate crops that had been planted prior to the transaction. So that's not going to be covered in a vacant land sale agreement. If that's something that would be relevant to your transaction, you'd want to use the agricultural sale agreement. UCC filings for any crops or timber or livestock or other equipment or accessories that would be used in an agricultural setting. That's in the ag agreement, not in vacant land. Items related to accessory vehicles, assignment of grazing rights, assignment of timber rights, and assignment of mineral rights. So again, on any of those rights, if you had a property that otherwise looked like vacant land, but there were a mineral right or a timber right or a grazing right related to it, use the agricultural agreement so that your clients can deal with that and are protected and are appropriately dealing with rights and obligations related to those rights. More time period provisions on the agricultural sale agreement that are not in vacant land. There is a Agricultural Foreign Investment Disclosure Act of 1978. Okay, this is a tax-related law, similar to kind of a FERPTA type of law with agricultural land. And there's a specific definition of agricultural lands that's associated with that particular law. Okay, so I have listed that definition here. That definition is not in our agreement. Okay, but it is the definition that's referred to in the section of our agreement here, describing the Agricultural Foreign Investment Disclosure Act. So I won't read this in detail, but if that definition applied to the property, use the agricultural sale agreement. Okay, because you want the agreement to have this provision in it relating to Agricultural Foreign Investment Disclosure Act. Okay. And we'll send out a copy of these slides so that you have that. So our general terms, this is the final section of our documents. They're not time period associated. They're not like the specific terms that you're filling in, but the general terms of the agreement. In our agricultural agreement, we deal with something we call accessories. So in addition to fixtures and personal property, we created the category of accessories to deal with certain types of farm related equipment. That is not in the vacant land agreement. Okay, so if and I don't think there'd be any confusion on this, but if you were ever in a situation where you had to deal with what we're defining as accessories in the agriculture agreement, then that may be a better fit for your transaction. No sale of business. So this shouldn't be relevant, but even in our agricultural agreement, we do not allow that document to be used for the sale of a business. Here, if there was a sale of a business, I think it would probably be quite clear that you're not dealing with vacant land. So let's talk about the disclosure document. As I mentioned, it's not required by Oregon law. The Oregon law on seller property disclosure statement only applies to the real property that's improved by 1 to 4 dwelling units. However, we thought it was important for all transactions using our forms to include relevant vacant land disclosures. So we've created that as a contractual obligation. Here's the language in our document related to that. It's in section 27 of our vacant land disclosure. And as you can see, it sort of mimics the statutory seller property disclosure law by giving buyer a 5 business day period to terminate if they disapprove of the vacant land disclosure document after it's been delivered to them. Some of the differences, though, and how this would play out are important for you to understand. And one is that if a buyer was terminating based upon the vacant land, disapproval of the vacant land disclosure, they would use our Form 5.3 buyer's notice of termination. They would not use the Form 5.7 revocation of offer, which is only for use with the statutory seller property disclosure statement. So in our library, we have a specific document 5.7. If a buyer is revoking based upon the seller property disclosure statement statute, that's only going to be for those residential properties where the seller property disclosure statement's used. If it's the vacant land disclosure that is the reason for the termination, use our 5.3 buyer's notice of termination. And then similarly, we don't have a provision spelled out up there in section 27 that we're showing you where we say that if the vacant land disclosure statement is not provided, then the buyer could terminate at any point up till closing, which is part of the residential seller property disclosure statement law. However, our contracts already deal with that because our contracts have the notice of default and opportunity to cure. And anytime one party to the contract is not fulfilling an obligation, the other party can send the notice of default and opportunity to cure, informing the other party that they failed to comply with an obligation of the contract, giving them a period of time to do it, and then giving the person who sent the notice an opportunity to terminate and to keep earnest money if ultimately the other party did not comply. So in an instance where the seller did not provide the vacant land disclosure document, the way you deal with that would be buyer would send our Form 5.1 buyer's notice of default to the seller, give the seller a period of time to provide the document. And if seller did not provide the document, buyer would be able to then terminate using our Form 5.3 notice of termination. So the rights are the same, but as it would be with residential, but it's driven by a contract rather than statute. And the process is a little bit different to actually effectuate the termination. So there are differences too in the content of the disclosure statement. The statutory seller property disclosure statement, because it's defined in statute, we don't have any wiggle room to make changes to it. So that residential disclosure statement you're all used to seeing has been the same for quite some time. Occasionally the legislature will add a piece or make a tweak, but we can't just go in and modify that. Whereas with the vacant land disclosure document, we had a lot of flexibility to create one that we thought was most relevant to this type of transaction because it's not defined in statute. So we've really expanded upon the items that are related to land usage. Okay, so here's a snapshot of our vacant land disclosure statement and the land usage section. You can see we have a section here related to zoning classification of the property, if that's known. A question related to any mineral, subsurface natural gas, oil rights, or leases on the property. So some of these are the same as what would be in the seller property disclosure statement, but we've gone into more depth and detail on some of them. We've also added a section on flora and fauna. So this is not in the residential property disclosure statement, but we have a whole section on it here in the vacant land disclosure. This is really to help identify if that property is being used or is subject to any migratory pathways for wildlife, for example. That's not something that would be immediately seen or known just by viewing the property, but is going to be relevant. And so we wanted an opportunity to disclose that. Dead or diseased trees, okay, which could create both cost for a person purchasing the property, but also liability if the diseased trees were to cause damage on other property through the spreading of disease. Forest management plan, the Oregon Coastal Management Program, okay, which has specific regulations and requirements related to those properties that are included in that program. Farm deferral or forest land deferral for county tax assessment. Any other environmental regulation or condition such as wetlands determination. So these are all things that maybe you wouldn't know just by looking at the vacant land. Maybe you wouldn't even figure out by doing some common inspections. And so now there's an opportunity for that to be disclosed. I see a question here. If Oregon doesn't require the seller to provide the VLD, how can the buyer terminate if seller doesn't provide it to the buyer? Nancy, that's a good question because it's a contractual obligation, right? So there are statutory obligations, but those are pretty few and far between. Most obligations in a sale agreement are contractual obligations. The parties are signing a contract that is an agreement that they're going to do certain things. And if they don't do those things, then they're going to be in default under that contract. And then we have a process to deal with that default and the termination that results. So the answer is that our contract and most contracts predominantly include requirements that are defined by the contract itself rather than by Oregon statute. All right. So that's the flora and fauna section. We've expanded the section here on soil and water as well. Okay. Water rights, of course, there were water rights questions in the regular seller property disclosure statement. We've expanded on those. We've asked about any soil tests that have been performed, anything classified as high value farmland, any known contamination, soil or groundwater. We've asked about dams. Okay. Potable water supply. And then we've asked a series of questions about connections to water, connections to water systems, and information about wells. Now on wells, as I mentioned before, we have our well addendum. You're also able to use that addendum to create additional rights for the buyer in terms of termination and inspection. And we can talk more about wells later because a question often comes up about whether for a vacant land property, is the seller required to do the tests for the well and report those to the state? So I actually have a slide later in the presentation where we'll talk about that issue. This is more on the soil and water here. Okay, we've asked about sprinkler systems, easements to maintain a water source, any abandoned wells, storage tanks, debris or waste. We have a series of questions on sewage systems. Power and heating. Okay, and these are, related to things that are going to be existing at the boundary of the property. Obviously, there's no structure here. So some of the questions that are in the seller property disclosure statement related to a structure itself, we've removed those, but we've tried to maintain and then add questions that are going to be relevant to sort of access to electrical, natural gas service, and other utilities. And then a miscellaneous section. Yeah, I see there's a question. Let's see what that is. Oh, already answered that. All right. So then let's Q&A. Okay, so I mentioned this. So wells and vacant lots, we often get asked, what are the requirements under Oregon statute related to the well and a vacant lot? So the statute that requires the seller to test for arsenic, nitrates, and total coliform bacteria. It states that it applies to wells that have been made operational to supply groundwater for domestic purposes, but capped domestic wells on unimproved lots are not required to be tested. So the way that I would read that is that if there was a well that was made operational for domestic purposes, and let's say there was a former dwelling unit on the property that's been demolished, but that well is still there and was made operational for that, I would say you need to test the well. If it's been capped, then you wouldn't need to test the well. However, the buyer still may want those rights, and they still may want any information that the seller has related to the well, and the right to terminate and the right to do any inspection. So I would still encourage the use of our well addendum anytime there is a well, even though that statutory requirement for the seller reporting, may not exist if it's a capped domestic well on an unimproved lot. And again, there may be a situation where it's going to be difficult for a buyer to test if it's a capped well, but our well addendum isn't just about testing; it's also about the seller providing any documentation to the buyer related to the well or the water quality. So I think it's a helpful protection for buyer to always be using that if there's a well. All right, so that was the only prepared content I have, and this one's a little bit shorter because I think most people have already been through our presentations to understand our agreements. I just wanted to highlight some of the differences. So I'm going to open it up for Q&A, and if there is no Q&A and we have not hit our 50 minutes, I'm going to pull up the vacant land sale agreement 1.5 and just start going through it section by section. All right, questions. This is what you like. What about tagging the wells? Well, so the requirement to report to the state is going to exist per the previous slide I showed. Okay, if it's a well that's made operational for domestic purposes and is not a capped well on an unimproved lot, then the requirement that it be identified, okay, that and tagged. That is a great question. There is a separate statute on that requiring that to be done within 30 days of a sale if it wasn't already done. And I will get back to you on the answer to your question because I need to take a look at that statute to see what it says particularly about this situation. Patrick says, I think all wells are required to be tagged upon sales unless it's already done. Yeah, and that's probably accurate. I just want to double check the statutory reference. Yep. All right, any more questions? All right, I'm going to open up the chat here too to see if anybody had anything in there. All right, so what if the property is raw land in floodway versus floodplain? Both have buildability ramifications for buildability. Yeah, so I presume that question was related to disclosure. So if the seller is aware of any designation or limitations on development of the property related to its location or designation related to waterways and the capability of flooding, then that's something that should be disclosed by the seller as a material fact in the transaction. Someone pointed out a typo, appreciate that. Question, what if there's an RV hookup and electricity? Do we still use the form? Yeah, so if there's no dwelling structure and it's not being used for agricultural purposes and it's not being used for commercial purposes, but there's RV hookup and electricity, it would still be a vacant land sale agreement that you would use. Any other questions? All right, well, keep them coming. I will go ahead and just pull up the document so that we, oh, one more. Okay, what if seller planted timber on adjacent property they thought was part of their property? Who owns the trees? How would the buyer be treated in this situation? Well, in terms of who owns the trees, that's going to be a much more complicated fact-specific analysis depending upon like how long this has occurred and whether it was apparent to the neighboring property owner and if there's any sort of adverse possession claim and all of that. So that's we're not able to answer that without the very particular facts of the situation. But in terms of the buyer, so the buyer is going to be buying the actual legal description of the property. And so, of course, if the seller is aware that there's been a mistake that was made, they need to disclose that to the buyer. And that's part of those disclosure documents and the representations is that there is no sort of, dispute or apparent differences between the actual and apparent boundary lines of the property. So those are things that would need to be disclosed. And if there was a mistake that was made, again, the buyer is going to be actually buying that legal description of what they're purchasing. Related to the remedy for the buyer, depending upon whether that was a mutual mistake of fact, they both thought the same thing, and there wasn't an obvious way to tell that it was inaccurate, then there could be remedies for a buyer in terms of rescinding the contract or, depending on the facts, damages. But in terms of what they've actually bought, it's going to be the legal description of the property. I'm not sure if I answered your question or not, but feel free to do a follow-up. All right, keep them coming. Any more? Okay, I'm gonna stop share and then pull up the actual sale agreement document. So feel free to keep the questions coming. Here's the actual document. For those who haven't seen the rest of our presentations, just overview of how we've structured this. We have final agency acknowledgement as the first page. We've used a whole page for that. We provided more space for additional disclosure of agency relationships. So if there's teams involved, for example, you have 3 spaces for buyer's agents and 3 spaces for seller's agents. We also have included here on all of our documents 4 spaces for buyer signatures and 4 spaces for seller signatures. We've used that full page. We've separately numbered it 1 of 1. And then we start our actual purchase and sale agreement on a separate page that's also numbered 1. Okay, so it's always going to be in the packet that you're going to get this final agency acknowledgement, but the numbering is separate. And so you can think of it as kind of an attached document that's just always included. In terms of the vacant land agreement, we start with our specific terms. We use about a page and just the top of the second page to get through all of those. Those are the terms that are unique to this particular property, transaction, and parties. Then we have our time period terms. Those are the terms that are the parties are going to pick a number of days for something, or there's already a pre-printed timeline for something, but everything that has a timeline involved. So those provisions take up another about 3 pages of the document. And then we get to our general terms. Our general terms, there's no room to modify anything. You're not changing. There's no date fields. There's no open fields for input of information. These are terms, generally speaking, that are not going to be modified because they're kind of the legal underpinnings of the agreement. Okay, a couple exceptions to that might be if the closing cost allocation that we've laid out here or the information related to the proration of taxes and fees and utilities and such needs to be different than what's printed here, you could use a general addendum to make those changes. But other than that, really shouldn't be changing anything in this general term section. And then we get to our final page of the document, on page 10, and that includes, well, on this one, starting on page 9, because we have less content on this document, the buyer is going to pick a expiration date and time for the offer, sign and date. Seller is going to accept, reject, or indicate that they're countering. We have a counter offer form that they would include if it's a counter. And then if the seller is trying to accept after the expiration date and time of the buyer's offer, we have a form 2.3, which is used for late acceptance. And then seller signature date and time, and then a place for the agent to indicate that they have presented the offer. Okay, so that's the overall structure of the agreement. And then we'll just dive in to some of the specific provisions here. As we mentioned in the presentation at the top, we kind of describe how this document should be used. Okay, what is the use case for it? Also, just like our residential sale agreement, we are asking the buyer and the seller here to acknowledge that they have received and that they understand the Oregon Realtors buyer and seller advisories. Okay, a lot of the information in the advisories is going to be relevant to a vacant land sale. We recognize there might be some items in there that are specific to a dwelling, but many of those items are relevant here, and so we are requiring the use of those. We know that some folks have had some concerns about the length of our buyer and seller advisories, and also that there are initials spots on each page. But I did want to mention to you all that we have put out a version of our buyer and seller advisories that do not have initials on every page, and where we've used smaller font type so that they are shorter. Those are available on our forms website. If you go to the forms page and the review all forms, if you go to that page where there's a drop box there, you can grab those shorter versions. We've also put it on our regular website at OregonRealtors.org, and then we will be putting it into your SkySlope and your Zip, etc. accounts. We're in the process right now of a series of updates we're making to the forms that we plan to release likely on June 1st. Stay tuned for more detail, and that will be included there. I see that there's a question. I'm sorry, but I did. Okay, Nancy asked, I'm sorry, but I didn't notice if there was any provision for a road maintenance agreement on the vacant land disclosure. Is there? That is a good question. Let me pull that one back up and we can take a look. I would say this, that would need to be disclosed. Okay, because that is going to be a material fact related to this property that a seller would need to disclose regardless of whether or not it's included in there. So even if it's not, be sure that your client is disclosing that. But let's just pull up that document real quick. Oh, sorry. Oh, I'm sorry, guys. I don't have that fully up here. I don't want to waste everybody's time. So I'd say take a look. I don't think it's on. Well, I don't want to say, I'm not certain if it's on there, but the answer again would be, regardless of whether it's on there, that's something that should be disclosed in a transaction, because it's going to be a material fact that the buyer needs to know and that the seller would be obligated to disclose. All right. Any other questions? Okay. All right, let me pull back up our vacant land agreement. So again, almost everything else you're going to see here looks very familiar to you if you've done the residential presentation. In the presentation, we talked about some of the items that are not on here. And I think rather than continuing to go through this, I think we've hit our time, which is my main objective here. I was kind of filibustering to try to get you all to your 50 minutes. But I don't really want to go through this document section by section because I think everyone's sort of seen that presentation before. So why don't I just do a final ask here? Are there any questions, more questions that you want to get answered on this agreement before we end the presentation today? All right, I don't see any questions. So everybody, we've hit our 50 minutes, so feel free to drop off. You will be getting follow-up information on the CE credit. Thanks so much. And if you do have additional questions, you always can drop into our 11 o'clock on Friday open houses. Check out those other presentations that we have available on the website. And you can also always email us at either forms@OregonRealtors.org or legal@OregonRealtors.org, and we will answer your questions. And you can also, on our forms website, we have a link for you to submit suggestions for forms. So if you do have suggestions for updates to forms or new forms that we don't have, make use of that. And we are, as I mentioned, in the process right now of pulling together some updates that we're going to launch here within the next month or so, and stay tuned for those details. Thanks, everyone. Oh, I do see a Q&A, and so I'll see if, oh, Nancy, thanks, of course. Thanks for being here and for all the great questions. Have a great weekend, everyone.